tuning in again to Paul Turner, the immigration barrister at Imperium Chambers. Today, not surprising given what happened on Friday in the Upper Tribunal, which is the subject of this short broadcast, I am not in court, but after receiving the Upper Tribunal's order and numerous messages, I thought it would be helpful to put out a short programme explaining a couple of things. Firstly, the order that the court actually gave. Here is a summary of what the court provided. 1. All Balajigari type cases are stayed until the 16th of July 2019. A Balajigari type case is best defined as a JR based on a challenge to refuse leave to remain on the basis of tax discrepancies. 2. Within 7 days after the 16th of July, and this is interesting, the Home Office is to provide a note on their position as to the cases and serve it on the applicants involved. 3. Within 7 days of the respondent's position being received, the applicants may file a response. 4. Within 7 days, the applicants and the respondents are to agree a set of directions or short written submissions if they can't agree on directions as to how the cases should proceed. The reasons given by the Upper Tribunal, who agreed with the Secretary of State submissions, was that it was to allow the Secretary of State to consider and formulate his position specifically about the procedural aspects and how best to resolve the cases with it which raise similar challenges which are currently in the system. Secondly, and perhaps most importantly, the other matter of interest is what can be done in respect of an individual who presently cannot work, because I indicated previously the court asked the Secretary of State whether he would consider such requests. And in open court, the Secretary of State indicated that they would consider such requests. This has led to numerous inquiries as to what people should do, both generally and I've heard it mentioned in discussion with other lawyers. There are really three alternatives. One is sit back, do nothing, which is obviously a very painful position for those that can't work and have families who need to survive. One is to write a bare letter, just asking for a right to work. Or secondly, preferably, with the help of a lawyer, prepare an application for a right to work, backed up by as much evidence that you can get, such as a statement, any letters relating to debts, any evidence that you were working or that you've got a job or that you've had to take out of loans. Now, given the reluctance of the Secretary of State to grant right to work to those without leave, I would strongly suggest contacting your lawyer or contacting me, the immigration barrister at Imperium Chambers on 0207 242 3488, by email at clerks@imperiumchambers.co.uk, or through Twitter, Facebook, or my personal website at www.theimmigration.barrister.co.uk. Why us? Well, we've previously had a number of successful applications. One in which we were involved with was at the Court of Appeal, and the other one, where the right to work was granted, was after we made an application to the Upper Tribunal specifically for the right to work, given the potential suffering to the applicant and the social utility to the United Kingdom. Anyway, I said this would be a short broadcast. This has been Paul Turner, the immigration barrister at Imperium Chambers, bringing you up-to-date news on the world of immigration as it happens.